Good afternoon, ladies and gentlemen. It's Alex Woods, civil litigator at Redwood Legal. We're a boutique law firm specialising in civil litigation, and historically, indeed this was something of the springboard for the firm a few years ago now, financial mis-selling litigation. We did a lot of financial mis-selling litigation as a law firm in the early days off of the back of the last recession, and we've had a couple of cases come our way recently, and there are some curious events afoot. If you're listening to this podcast, you will probably be someone who thought that their loans from those days was well behind them, thought that the debt had been written off or forgotten about, and you may have had a nasty surprise just recently and found a claim form from a company, perhaps a law firm, perhaps a debt recovery company, land on your doormat. Indeed, you may not even recognise this company because it will probably be a large debt purchaser who's purchased your Marks and Spencer's £1,000 or £5,000 house renovation loan or your car loan from 5, 10, 15, even 20 years ago. So I am here in the distinguished company of Mr. Richard Parsons, senior solicitor at Redwood Legal, who's been running these financial mis-selling claims that have just recently come our way. We're podcasting, and I'll just invite Richard to introduce himself.
Hi, yes, Richard Parsons, solicitor, working for Redwood Legal. I have come across a couple of these cases recently. They've caused me some curiosity, some concern, and I think that there might be quite a lot of people who are affected by these sorts of claims who currently aren't getting the legal help or legal advice that they need. Perhaps they're being a little bit bullied.
And they may be scared about approaching a lawyer and having to part with money. Is that right? Should they be afraid of the lawyers?
Well, I think they've got to get the right lawyer, haven't they? I think many firms who are doing litigation will expect quite a large fee straight away up front. They'll want £1,000, £1,000 plus VAT, so £1,200 immediately, even just to get going with the case. What they need to do is go to a law firm who specialises in this sort of thing and can have a proportionate approach to dealing with these sorts of claims, which otherwise are perhaps a little bit small.
Yeah, thanks, Rich. And so don't be alarmed if your claim is of low value, because the claims that we will be coming on to talk about in detail later on in this podcast are actually knocking about the £1,000, £2,000 mark. So stay tuned, because even for claim value that low, a law firm, the right law firm, may be prepared to take it on. Just to let you know, we're podcasting from the Law Society in London. As solicitors of England and Wales, we're both members here. Beautiful surroundings here, actually. Very good to meet clients. So if ever you need to meet us, for example, in London, then come along to the Law Society. Very nice. I think, well, it tastes like sort of exotic Lapsang Souchong tea that we're drinking here.
I think they call it Earl Grey. But yes, 113 Chancery Lane, the Law Society building, is a beautiful historic building.
Well, I stand corrected, and probably not for the first time in this podcast, but what else do you expect from a laser-focused financial mis-selling litigator? So we're going to cover, firstly, the landscape behind these types of claims. Then we're going to, in the second section, we're going to come on to the law and give you a little bit of a 5-minute law school on it all. Then we will look in detail at the cases themselves. We'll put some flesh on the bones, or we'll look into the nuts and bolts, before finally concluding by talking about, what you can do about it and what your next steps are. So, Mr. Parsons, would you like to sketch out the landscape behind this recent development?
Yeah, sure. So basically what's happened is there's a number of historical loans. So by historical I mean perhaps 5, 10, maybe even 15 years old, where the original lender has pretty much concluded that they're never going to get their money back. So I've come across, for example, loans from M&S Bank or Sainsbury's Bank in this sort of situation, along with other mainstream lenders. So for whatever reason, they've realised that they're not going to, or they've reached the conclusion they're not going to easily get their money back. And so what they do is they do a deal. They enter into a deal with another company who believes that they can get some money out of it, who thinks that there is some chance of chasing the debtor and getting something back. And effectively, they sell the loan to these debt collection, debt recovery companies who think that they're going to be able to get something back for them.
Could you give us some names? What are the names of these big debt recovery companies?
Well, one in particular, the one that I've tended to cross swords with, is a company called Cabot, who are based in London, and if I understand correctly, from their filed accounts online last year, spent about £1 million in buying these debts.
Sorry to interrupt, but when you say they bought them for £1 million, you mean they bought £1 million worth of loans?
No. What I mean is that I don't know what the going rates are, but the rumours, if you like, that I've heard are that they might pay something like 5 pence in the pound for these debts. So if you have a debt of, say, £1,000, then it might cost them £50 to buy that.
That low?
Yeah, absolutely. Because, as I say, this is a situation where the original lender has reached the conclusion that they're effectively worthless because they can't chase up the money. So they'd rather have something and draw a line under it and get rid of them than nothing. So when I say about £1 million worth of that they have spent about £1 million on buying loans, based on that 5% figure, just a very broad estimate, that would be about £20 million worth of loans that they'd purchased.
And that's quite a large amount of loans. I mean, I don't want to put you on the spot. Did you pass your maths O level? But you passed your maths A level, didn't you? In fact, you probably went on and did an S level, as they were then known. But how many potential people are there likely to be facing this kind of problem?
I don't know. I've done a bit of an estimate myself, and I imagine perhaps it's something like tens of thousands. Perhaps it's 5, 10, 15, 20,000 people who are facing these sorts of claims, and that's only from one debt collection company. There may be other debt collection companies that I'm less experienced in tackling who are doing the same thing. There's a whole market for buying up and chasing these loans out there. So yes, it's perhaps just the tip of the iceberg.
Can we segue into the law in this area? Is this legal? Can a big debt recovery company just knock on Sainsbury's door and say, "You got any old debt you want to get rid of? I'll give you 5% for it"? And what's the procedure?
Yes. Okay. So when we talk about one business buying the debts of another business so that they can pursue it, this is a legal procedure called assignment. And under the law, it's been done for very many years, and indeed the law, and it's quite old, goes back to the Law of Property Act 1925, which is still good law today, so almost a century old, which says that a lender can assign their loan to somebody else, can sell it to somebody else, but they need to give notice to the debtor. Now, if you think about it, that makes perfect sense. If you, imagine you had a loan with Halifax for £10,000, say, and I came along and said, "Oh, I've bought the loan off Halifax, stop paying them, pay me instead." Well, you might be a bit suspicious. What you would want to get is a notice from Halifax to tell you, you don't have to pay us anymore. So-and-so's bought my loan, they're the people to pay.
So I actually have to get notice both from Halifax and from the new debt purchaser?
No. The notice of assignment, the key party to get notice from is the assignor. It's the one who historically had your debt and is selling it on, because they're the ones who are at risk of being disadvantaged if you're tricked into paying the money to somebody else.
Right, I see. So, but if a claim pack from a county court does land on my doormat, I can kick up a fuss if the original lender hasn't already told me about it.
Yes, indeed, and it might not just be the original lender, because it might have been assigned more than once. Lender A might have sold it to Debt Collection Company B, and Debt Collection Company B might have sold it to Debt Collection Company C, and for them to successfully bring proceedings, they would need to have a notice of assignment for each of those steps. There is an exception, and that exception is that you can bring as an assignee, so somebody who's bought a debt and who's wanting to sue the debtor, you can actually proceed with a claim, but only if you bring the original assignor in as a party to the claim. In other words, you say to the court, the new owner of the debt says to the court, I want to go after this loan, and look, so-and-so assigned it to me, and here they are as a party to the claim. They're written on the claim form, they're going to be able to give evidence and so on. Although that's a legal possibility, it doesn't really make commercial sense, because it's so much easier for the assignor simply to send a notice rather than to get embroiled in the court proceedings.
That might be quite annoying for Cabot or whoever is the debt purchaser, because they might have thought they purchased this debt in good faith, and Halifax or whoever it might, Marks and Spencer, Sainsbury's, might have said, yeah, don't worry, we'll tell the debtor that we've assigned it, and then they might not, because you know what these big companies are like, they might not have told the debtor at all. Seems to be plentiful opportunity for bureaucratic cock-ups here.
Yes, that's true, but I mean, I've actually, over the course of the years, I have advised on assignment documents myself, and what tends to happen is that the notice of the assignment is just on the back of the assignment contract. So at the same time as signing the contract, the assignor also signs the notice, which can then be sent by the assignee to the debtor. So it should be part and parcel of the assignment, and frankly I don't know why this hasn't been taken care of properly. You would have thought that before handing over their money, these debt collection companies would like to get their ducks in a row so that they'll be able to issue proceedings. But from what I've seen on the number of cases that I've done, from what I've seen, often their ducks are not in a row. They don't have their assignment sorted out properly.
I suspect it's a low-cost kind of business. You know, you bought bad debt, you're just banging out the claims, turning the handle, and hopefully the bureaucratic machine is getting into motion, and you're scaring a consumer into settling the debt by threat of legal proceedings. You know, even though they might not have, because the consumer doesn't know that these steps need to have first taken place. Now, let's come on to talk about the sort of the substantive law. In other words, the defence that a consumer might have where these types of claims have been brought. Broadly speaking, my understanding is there is the law around the unenforceability of debts. There's a law called the Unfair Relationships Test, Consumer Credit Act as amended. I'll link these relevant legislation, folks, in the description box beneath this podcast. But what sort of law can the consumers rely on? What sort of justice can be wielded in their defence?
We've already talked a little bit about the failure to provide a notice of the assignment, which is one defence that, of course, a consumer wouldn't know about off the top of their head. It requires some technical information of the law in order to avail yourself of that. There are a number of other defences which are very similar. So the first one that's probably relevant is the Limitation Act. So under the Limitation Act, you've got a situation where, unless there's been movement, and I'll come back to what I mean by that, on the loan for a period of 6 years, then basically it's too late. It's too late for the lender to pursue it, and that can't be solved by assigning it. The clock doesn't start again if a lender assigns the loan. What I mean by movement on the loan is either that a payment has been made by the debtor. So, even if you've got a mortgage for 25 years, if you pay it regularly each year, it doesn't become time barred because each payment starts the 6-year clock again. And the second way that it can happen is that if there's any sort of acknowledgement of the loan. So, if you'd been contacted by debt collectors or something like that, and you'd replied and said, I know that I need to pay this loan, but I'll pay you when I can, then that would also start the clock running from 6 years. But my experience is actually quite a lot of these loans are historical and haven't been chased. There haven't been a payment for over 6 years, which is perhaps why they're being sold so cheaply, 5 pence in the pound or even less perhaps, by the lenders, because this is unlike the notice of assignment defence. This is a defence that actually normal people might be able to think of and take advantage of. They must know that they might suspect that if they've not heard anything about a loan for 5-10 years, that maybe it's too late for the lender to take it up and pursue it. So that's a very common defence.
So can I just try and clarify or summarise that? Traditionally, in law, most other causes of action, defences, whatnot, the 6 year, which is the common, but there are exceptions. It could be longer. For example, under the Consumer Credit Act, unfair relationships test, it could go up to 12 years potentially. But leaving aside just a normal bog standard claim, say a negligence claim or a contract claim, the clock is running from the date of, in the case of negligence, when the Negligence Act occurred, when the cause of action arose, and in the case of contract, where the contract's been breached. Yeah, that's relatively straightforward. But I think you're saying that in this area, you might have signed up for a loan in 1995 for 10 years or something, and you run the clock from basically the date of the final payment on the loan. Let's say the loan was 15 years. You make the final payment on the loan in 2010. You've got 6 years from 2010 to bring a claim, broadly speaking. Or the other situation, which just like you to clarify, where you've acknowledged the debt. Wasn't quite following that point.
Okay, so in relation to the final payment issue, I'm not saying that it's the planned final payment. What I am saying is it's the final actual payment, an actual payment made by the consumer. So even if you had a 15-year loan, if you only paid it for a year and then you stopped making payments, even though you were meant to make more payments, the 6-year clock begins on that last payment that you made.
Even though there may be a large part of the loan outstanding.
Yeah, absolutely. And basically, the maxim is that the law doesn't assist those who sleep upon their rights. So if the lender is not getting his money, he better get on with trying to sue you for it. And if he doesn't for 6 years, well, it's his fault. He should have taken some action.
So I think that summarises limitations. It can be an issue, and you won't be surprised to hear me recommend you seek the services of a lawyer to clarify that point, because it can be tricky. Honestly, it can be tricky. What about the actual sort of substantive defences under? When is a loan unenforceable, for example?
Okay, so there are other potential defences that we can take advantage of. One is in relation to something called the unfair relationship test. So this was a law that came in as an amendment of the Consumer Credit Act, and it replaced an old piece of legislation called an extortionate credit bargain. And the basic principle of the unfair relationship test is to say, is there anything which has been done by the lender which renders the relationship between the lender and the debtor unfair.
That can include a debt company who's bought the debt.
Yes, absolutely. So if somebody else has bought the debt, they're now the lender for the purposes of the unfair relationship test.
And if they've conducted the things unfairly, that can be part and parcel of your defence.
Yes, absolutely. Now, there are some technical advantages in using the unfair relationship test. One is that it's very broad in terms of what it can consider. You know, unfair is something that has been done, made the relationship unfair, is all-encompassing. Anything that they've done might make it unfair. And so almost sort of any small matters that shouldn't have happened, or the lender has done they shouldn't have done, are things that you can bring in under that test. So it's nice and wide. The remedy under this defence is that the court has to take such steps as to make the relationship fair again. So that might be reducing the amount of the loan, writing off the loan altogether, putting restrictions on the lender about how they can enforce it, and so forth. There are some technical advantages, as I mentioned. Another technical advantage is that the unfair relationship test reverses the burden of proof. So what does that mean? Normally, when you're defending something, in order for your defence to win, you need to prove it. In other words, you need to bring evidence before the court to show the court that you're right. That normal rule is turned on its head for the unfair relationship test. What happens is that if you allege that the relationship is unfair, then it becomes the lender's job to prove that that's not true. They have to prove that the relationship is fair, which means in cases where there's very weak evidence between the parties, the defendants have the upper hand. The default position is that they will win.
Yeah, that's quite an important point, because obviously you're talking about paperwork, old paperwork that's been archived by banks, probably half of it lost. So it's quite a scary cause of action. Folks, for those of you who don't know what a cause of action is, I mean, basically, you can't get yourself into a county court in front of a judge in a case unless you're hanging your issue, the wrongdoing or whatever it is, off the back of a cause of action. It's like a gateway that you have to pass through in order to get the judge to side with you. So yeah, it sounds to me, if I was a bank, I'd be a little bit scared of that cause of action.
Yes, unfair relationships is interesting because it's something that can be used on both sides. So it can be used as a cause of action. You can begin a claim, begin a legal action with it, but it can also be used as a defence. So it depends which way you want to use it. I think unfair relationship is very useful because it's a wide catch-all. It'll be available to almost everyone in this sort of situation, and anything that you're unhappy or think is unfair can probably be brought into the proceedings under it.
Okay, and now we'll start to segue into the actual cases themselves, but just first touch on the issue of unenforceability, which relates specifically to these cases, because in these cases we're about to talk about, the unfair relationships test wasn't deployed. But just if you could outline the unenforceability cause of action, Richard, and segue into talking about, giving us a little sort of a brief summary of the cases you've been running.
Okay, so yes, unenforceability. So here we're looking at a particular section of the Consumer Credit Act. It's called Section 77, and the following sections, and it outlines a right for debtors, and that right is that they should be able to ask the lender for a copy of the loan agreement. So if you've made a loan agreement a year ago, 5 years ago, 10, 15 years ago, you might not have your copy of the loan agreement anymore. Somebody's knocking on your door saying you've got to pay £5,000, you've got to pay £10,000, you did a loan with us. You have a right to say, show me the loan. I want to see the loan agreement, I want to see my signature on it, I want to see how much I borrowed, I want to see what the date was, I want to see what the interest rate was, etc., etc. And how is this right enforced? Well, if you do ask for a copy of the loan agreement under Section 77 and the lender can't come up with it, they've lost it, or it's been destroyed, or whatever it is, then they lose their right to enforce that loan agreement.
And that's what's happened in the first of the cases that we're about to talk about, between Cabot, who bought a loan, sort of £1,000, knocking about £1,000 range, perhaps paid 50 quid for it, and I think it was Sainsbury's Bank or something like that.
Yes, so in that case, what had happened was they'd bought the debt, they'd issued the claim. By the time it came to me, it was actually very far progressed. So they had, the claim had been bought, so they'd issued county court proceedings, they'd used what's called the Money Claims Business Centre, which is where they're able to issue claims online without filling in any piece of paper. The court presumably sent out a copy of the claim to my client, though unfortunately it was never received. I don't know whether the address was wrong or whatever the reason was, but it wasn't received. Sometimes happens. The claimant, the lender who'd bought the loan, then asked for what's called default judgment. Default judgment means there's no defence, nobody's filed a defence, the defendant's not got back to us, has not got back to the court, so I win by default. And that's what happened. Once they'd got the default judgment, they didn't stop there. They then applied to the court for what's called a charging order. Now, a charging order is where you convert a county court judgment, CCJ, you've probably heard of those. They'd already got their CCJ, that was the default judgment. They converted that into a mortgage over the house. So,
well, that's quite serious stuff for a little piddly £1,000 debt.
Yes, it was. I can't remember the exact figure. It was a little bit more, I think 1,500 or 2k, something like that. But yes, the first my client heard about it, they got a letter through the door from the Land Registry, which said, "Bad news. Somebody you've not thought about for the last 15 years sold a debt, and now it's a mortgage over your house. So you can't sell your house without paying this off. You can't remortgage without paying this off." And by the way, the interest rate's 8%, so if you don't sort it out promptly, it'll just go up and up and up until eventually somebody does want to remortgage or sell the house.
Goodness. And that, yeah, there must be, if you're saying there's perhaps 10, 15, 20,000 more, a lot of people might be quite alarmed and afraid that these debt companies are going to roll on get a charge on their property, particularly if there's been some bureaucratic what's the polite word, mismanagement. So what happened what was the outcome of this case?
So in those circumstances where judgment's already been given, you have to apply to the court to set aside the existing judgment, and in that situation I needed to show the court firstly that there was a real prospect of successfully defending the claim, and the way that I did that was I drafted a defence. The defence said the sorts of things that we've been talking about. They didn't serve notice of the assignment, they hadn't properly, so a specific item in this case, and I think it's very important for our listeners, viewers, to consider the fact that each of these cases turns on their own facts. Whilst I trot out some of the relevant law, there's always, it always needs thinking about and applying into the individual circumstances of each case. Well, in that particular case, the original lender, the lender who was alleged to have assigned the debt, didn't appear to be a real company. I looked them up on Companies House, I tried to identify who they were, but they didn't seem to exist. And so that in itself, a failure to identify a real lender, seemed to be a reason to defend the claim.
But wasn't the fact that was Cabot the claimant?
Yes, Cabot was the claimant, but their claim was that they were entitled to pursue a debt because they had bought it from XYZ company.
So they have to identify the name of the lender in their claim form?
Yes, indeed, that's what they'd done. But the name of the company didn't make sense. It wasn't a real company. And so that alone cast a lot of suspicion over the validity of the claim that they were bringing.
And in what other ways was their claim deficient?
I wasn't happy with that. There was a lot of other small details. One was that when you issue a claim form with particulars of claim, there are requirements set out by the court about what that should include. And two of those requirements, which I thought were relevant, were first that there should be a copy of the original loan agreement. Now, a copy of the original loan agreement wasn't attached.
How old was this loan?
Oh, I don't remember. It's very old. 10 years, more, 10, 15 years. So there was no copy of the original agreement, which, would have been helpful because we could have then seen what the name of the lender was, since that didn't seem to be right either. And that was one deficiency. Another deficiency was that there was no proper statement of account. If you're bringing a claim under a loan agreement, what you expect is a statement of account, like a bank account. It says, you took out your loan for £5,000, you made a payment of £100, so now you owe £4,900. But we added interest, we added £10 interest, so now it's £4,910. Then you made another payment of £100, now you're down to £4,810. And you would expect an account, a rolling account, that showed you the original loan balance, the payments that have been made, the interest that have been added, any charges that have been added, so that you can see if what they're claiming for was right. Well, they had attached a statement of account, but instead of being as I described just a moment ago, it only had a single entry. It just said loan amount on assignment X, and that was the figure that they were suing for. So there was no background, no explanation at all, no evidence at all of how they'd reached that figure. It could have been hundreds, thousands of pounds out, and we had no way of looking at the calculation.
So it looks as if, and this is a bigger conversation, the way in which at least two of these claims that Richard's dealt with were deficient, but it looks as if these really were rather fanciful attempts to get money off of old consumers' old debts. I mean, really very fanciful. Is that right? How did you manage it, and what was the outcome of the proceedings?
Yes, so in terms of how I managed it, I made an application to set aside the judgment, and I attached a draft defence to that. And normally what happens is the court will then send it out to a local, the business centre, which is dealing with claims nationally, will then normally send it out to a local court, and the local court will hold a hearing to decide, is there a real chance of defence? Have the defendants done something about this judgment promptly? And if so, we'll set aside the judgment and let them have a crack at fighting it. Or if there's no real prospects of defence, or if they were very slow in trying to set aside the judgment, then the court will allow the judgment to stand. Well, I was very lucky in my particular case. Once it was farmed out to a local court and went in front of a judge, that judge approved my application to set aside the judgment and ordered that my defence should stand without a hearing. They presumably looked at my defence and thought, this is obviously a good defence, I don't need to have a hearing to decide whether or not there's a real prospect of defending this matter. If I have a hearing, I already know what I'll decide, so I won't bother with a hearing. And it sort of tickled me that when I'd created a draft defence, I hadn't signed it because it wasn't a real defence, it was only a draft defence, and the judge themselves crossed out the word draft and initialled it with their own initials to mark it as the defence that was going into the proceedings.
Interesting. So, good plus for the court there. I mean, the judges, are smart. They know how to deal with these matters now. And so did the claimant, Cabot, did they fight on and go for the hearing?
No, absolutely not. So as soon as I put up a real defence, they folded. And what was interesting about that was, so in technical terms that's called discontinuing. They served notice of discontinuance at court, which said they weren't proceeding with their claim. Now, what was interesting was that they said that the reason that they were discontinuing was under the Section 77 argument, under the argument that they there'd been a request for a copy of the consumer credit agreement, and they'd been unable to provide it. Now, what was so interesting about that was that it wasn't one of the defences that I'd raised, because my client hadn't given to me any request under Section 77 for a copy of the loan agreement. So they folded their case on the basis of an argument that I hadn't made.
It almost sounds as if they were just waiting for a solicitor to get hold of the case and, see through it, because it's quite difficult for a consumer to get their heads around that.
Yes, I think what's really going on here is that these debt collection companies are aggressively pursuing matters against consumers where consumers aren't represented, because you just do the maths. If they issue 100 of these claims, then perhaps only 5 or 10 people out of that 100 go to solicitors. The ones who do, the debt collection company folds, forgets it. We're not going to get anywhere with this, and just collapses the claim. The other 90, off they go. They get their judgment. The consumer doesn't know how to defend them. The courts don't even bother looking at whether or not to. The courts don't even bother looking at whether or not there's a good claim. If there's no defence filed, they just automatically give default judgment. There doesn't have to be any claim.
And you've got a consumer who's, absolutely terrified of a charge being put on his house.
Yes, and how can they be expected to know the technical steps to defending these? How is a normal consumer going to know about the unfair relationships test and Section 77 and Law of Property Act 1925 on the assignment of a loan, etc., etc.? It's just impossible. And I think the debt collection companies are existing in that gap. They're making their money out of that gap in legal knowledge, and that's what I find unjust. Yeah,
sticks in your craw a bit.
Yeah, absolutely, and the reason why I'm doing this podcast. So yes, in that particular case, they filed the notice of discontinuance. I said then, I didn't know my client had asked for a copy of the Section 77 agreement. Can you send me a copy of his request? Because I thought it was very strange that they were folding under a defence that I hadn't raised. Anyway, they did send me a copy of a letter which had included a request for the original agreement, though it's sort of a side effect of other things that it was raising. It's sort of a general outraged letter from my client. And we then came to the question of costs, and I simply said, well, you've issued a claim you shouldn't have issued. You should have known, you should have checked it properly, you should have issued it properly. You would have known you shouldn't have issued this if you considered it, a little bit thoroughly. And so, as a result, I asked for my legal costs to be paid. And again, the debt collection company very quickly folded, immediately handed over, well, there was a small negotiation, but they basically handed over almost all the money I was asking for.
So let's wrap up by moving on to the final section of costs and whether you should use a lawyer, go it alone, or how you should handle this if this is a problem that you're facing. What costs did you get from Cabot? Okay,
so just in that particular case, as an example, initially the client paid to me, I think it was about £500 or £600 to get me on board as a representing lawyer so that I could review it, advise on it and so forth. In order to make the application for the application to set aside the default judgment, there was a court fee to pay, that was £255. And then the cost that I was paid in conclusion was in the region of about £1,600. So that meant by that point I was able to reimburse the client all the money that he'd given me. I was able to reimburse to him the court fee that he'd paid, and I invoiced all the rest of my work on the file and used what was left to pay it. So the client was delighted because he'd paid a bit of money to fight the thing, but he'd got every penny back.
Really? So he put a bit of upfront money, £500 to £600 plus £250. So not that far from £1,000, even though the debt was £1,000, but then the consequences were serious for him, obviously. And he didn't actually part with a penny. Is that right?
Well, by the end of it, by the end of it, he'd had the whole service. We'd got rid of the loan against him. We'd got rid of the mortgage against him. It was off his house, and he'd had every penny paid back to him. So I think in the future, if I were doing these claims, now as I've become more familiar with this particular debt collection company and so forth, the figures might be a bit different. I would look at individual cases and decide what I thought was reasonable to pursue them.
Yeah, because I reviewed the file before this podcast, and I did get the sense that you'd actually done a lot more work than £1,600 on the file. A lot more, actually. You probably don't know this, Richard, but I worked out the maths. So, but perhaps going forward, because this is technically a small claim of under 10,000, but for you listening out there, and we've just been talking to a senior barrister who specialises in this area, he said a claim is just a claim when it's first issued. It's not a small claim, not a fast-track claim, not a multi-track claim. It's just a claim. Don't think that normal cost rules don't apply, i.e. the loser pays the winner's costs. It's only quite an advanced stage of proceedings once the pleadings, statements of case. I mean, these cases occurred a long way before the case was settled, well before the case was actually allocated. And it might have been allocated to a fast track, even though it was under 10,000 because of the complexity. So you may be wondering, well, small claims, surely you don't get your costs back. Well, yes, you do, especially if the case hasn't been allocated yet. Okay, if you're a litigant in person, I guess my concern there would be if you get it wrong, and I know we're lawyers and our job is to sell legal services, but if you get it wrong as a litigant in person, you could end up on the wrong end of a cost order, because these debt recovery companies are well off and they will employ barristers to fight these and solicitors to fight these claims.
Yes, so the debt collection company that I was dealing with, not only do they use solicitors to fight these claims, they own solicitors. So within their own group, they appear to have set up their own solicitors, who all these solicitors ever do is chase these outstanding claims. So, in a sense, the solicitors are kind of bought and paid for by the company. There's nothing wrong with that. People can have their own in-house solicitors. People can set up their own in-house law firms. There's nothing. I'm not saying there's anything wrong with that. But yes, this is all. You're definitely going to end up against a specialist solicitor because they have their own solicitors who do nothing but this.
All right. Well, I think we better wrap up there. This is a big topic, and I'd love to talk to you more about it, Richard, in the coming months, perhaps in 2020. I would just explain that Richard runs his operation from Nottingham branch office of Redwood Legal. The head office is in London, and so if you need to get in touch with Richard, what are the contact details that they should use?
Yes, if you want to get in touch with me, you can send me an email. My email address is rp@redwoodlegal.co.uk, or the alternative would be to go on our website, www.redwoodlegal.co.uk, and that's got the telephone numbers if you prefer to give us a bell and speak in person. But yes, very happy to speak with new clients, be delighted to help you.
All right, and I will just finally just say I am actually bringing out a book in the new year. I will be bringing out a free or a 99 pence section of that book, part one of that book, before Christmas. It's called Flying Solo, and it is a book designed to act as a paperback wing for people who are bringing their own cases, representing themselves in the county courts of England and Wales. So look out for that. I'll be announcing that more formally on one of my YouTube channels. Now, I'm a big proponent of litigants in person running their own cases, but I do caution against cases where you are drifting into an area of complexity, and financial mis-selling issues, I'm afraid, is complex. The problem is finding a lawyer who's going to do it without emptying your bank balance. I think in this area at least, you may well find law firms out there who are prepared to do it because, as in the case of the example that Richard gave, they can often get their costs back from your opponent. Every case is different. There's a big caveat to this whole podcast. Legal advice needs to be tailored to always needs to be tailored to the individual circumstances of your case. Just a final thing. We do offer a service, like you can ring up and get a legal surgery for a discounted rate if your claim is under 10,000 of 150 plus VAT, or a tailored review, 2 to 3 hours, which is pretty much what Richard did in the example that we gave. Or, of course, you can actually instruct us to go on the record and conduct the entire proceedings on your behalf. That might sound like alarmingly expensive, but I hesitate to say, Richard will correct me if he disagrees, you could look at talking to the law firm about a no-win, no-fee arrangement, or a reduced no-win, no-fee arrangement, because if the law firm feels it's a strong case and the other side are going to pay the bill, they might well be prepared, providing you put some money up front, to entertain a contingency arrangement.
Yeah, absolutely. Maybe it would depend on the circumstances of the individual case, I suppose. I think the reality is people do need to deal with these, because otherwise they're going to end up paying on these loans when they shouldn't be. They're going to end up with CCJs against them. It's going to ruin their credit history. They're going to end up with mortgages over their homes. They're going to end up with interest payments, when in actual fact, if they defended their rights, if they had the right legal representation, they'd be able to avoid paying all these things altogether. So I do think people need to bite the bullet and take legal advice.
Yeah, thank you very much, Richard. I think we'll wrap up there. Stay tuned for future podcasts and future vlogs on our channel on YouTube. Just YouTube in the search bar, Redwood Legal. It's goodbye from Alex Woods, goodbye from me, and it's goodbye
from me, Richard. Thank you very much.
Bye for now, folks.